All right, we are going to dive into a deeper understanding of copyright law, and specifically in what types of works are created are covered and which types of works are not covered by copyright. So there's definitely some very clear boundaries there, including what you can copyright and what you can't, and what elements of that can be protected and what might lie outside of the scope of copyright law. So I think it's important for writers, artists, musicians, content creators to understand the limitations of copyright and to help navigate the complexities of it to protect your intellectual property rights. I get the fact that this particular product or topic can be quite boring and dry. It's illegal, but I think that you need to address and understand copyright, in order to be a creator and know how to protect yourself, because I see so many times artists and creators and writers being taken advantage of, just because they didn't know their rights from the start. And once you sign a contract and sign your life away there, let's face it, the big business is going to win because they have more lawyers to throw at it. And so as the small guy in the room, chances are you're probably going to lose unless you can protect yourself from the very beginning. So we're going to go into more detail about what can be covered and what can't. So you're talking about what can be covered: your original works of authorship. Okay, so that includes literary works, artistic creations, musical compositions, dramatic works. It has to be fixed in a tangible form. So it has to be in writing, it has to be painted or drawn, recorded, or in some sort of digital format. Creative expression can be covered by copyright. It's the expression of ideas rather than just the idea. So it has to actually be expressed in some way in order for it to be protected. It just can't be the idea. And then derivative works. So copyrights do extend to derivative works, which are new works based on copyright material. So you're talking about adaptations. So if you wanted to turn a book into a movie, that would be an adaptation. It covers translations. So if you wanted to take your book and translate it to Spanish, that would be covered. And any other transformative works that build on or modify the original material. So things that can't be copyrighted. So facts. So if there are historical facts, those cannot be copywritten. They're facts. Ideas, if it's just an idea, a lot of people claim, well, such and such stole my idea. If you didn't fix it in a tangible medium, then it is not protected. So you have to actually, just because you have an idea in your head doesn't mean that it's yours, not until you actually fix it in a tangible medium. So systems can also not be copyright written. I think of the age old argument, if you want to go back to Dungeons and Dragons and the OGL debacle. To be completely honest, a lot of that was null and void because copyright does not extend to game mechanics. Game mechanics is simply just math and rules. It's a system or method, and those cannot be copywritten. Now, what can be copywritten is what's in the book, what's in the player's handbook. That exact wording is copywritten, but the actual mechanics of playing the game cannot be copywritten, so it is not protected. So technically, you can use any of that stuff. You just have to change all of the wording in it, which can be done. And discoveries cannot be copywritten. While the expression of these concepts may be copyright written, so again, if an idea is actually expressed or fixed in a tangible medium, the underlying facts or ideas themselves will remain in the public domain era. And that brings us to the next topic of what can't be copywritten, and that's public domain works. So anything that falls within the public domain or works created by the U.S. government, those cannot be covered by copyright. And then functional elements. So copyright does not extend to functional elements of a work, such as objects, industrial designs, or functional aspects of software. These elements may be protected by other forms of intellectual property. So you could use, for example, patents. If it was a functional element, that could be, you could do an invention patent on it for an object, or even a trademark. And then we all need to tread very lightly on the gray areas of fair use. And we will kind of touch on that a little bit more on the very specific areas to be considered as fair use. It is very subjective. It's up to a judge to decide whether it is deemed fair use or not if you find yourself in a lawsuit. So it's very important to, ask yourself some very critical questions before using somebody else's copywritten material.